Good afternoon, everyone, and welcome to the release of CfJJ's latest report, Mandatory Harm, How a Massachusetts Statute Forces Unreasonable Sentences. My name is Leon Smith, and I'm the Executive Director here at Citizens for Juvenile Justice. And that statute that is mentioned in the title is Mass General Law, Chapter 269, Section 10G, commonly referred to as the Armed Career Criminal Act, which when it's invoked, requires lengthy mandatory minimum sentences for individuals convicted of unlawful firearm possession offenses who have previously been convicted of certain other offenses. This includes juvenile adjudications committed years earlier while someone was still developing. And this statute does not allow the judicial fact finder to consider how a person may have worked to change their lives over the years since those prior offenses. Today, we'll walk you through how the statute, which is a relic of the overly punitive 1990s policies, which drove the harm of mass incarceration in this Commonwealth and across the country, produces racially disparate outcomes, punishments that are disproportionate to the given, that are disproportionate given the totality of a person's circumstances, and represents an overly harsh approach to addressing repeat encounters with the justice system. We'll also make recommendations on how key stakeholders can mitigate the harmful impact of these policies in order to ensure that our system produces outcomes that are more fair, just, and equitable. We will then feature a conversation with two experts in the field who will weigh in on the impact of this statute. We'll conclude our program with a question and answer session. Before we get started, I'd like to do a little housekeeping. We're going to have people who aren't presenting muted in order to avoid background noise. We're going to ask you to please hold your questions until the end of the presentation. However, please feel free to put questions in the chat if any arise during the course of the presentation, and we will get to them during our Q&A session at the end. We have invited members of the press today, so portions of this discussion may be quoted in the media. Lastly, this session is being recorded. As a reminder, our report is now live, and you can download it at www.cfjj.org/mandatory-harm. So now that we've gotten that out of the way, I will turn it over to Josh Dankoff, CfJJ's Director of Strategic Initiatives, who will now present the report's finding. Josh, take it away.
Thank you so much, Leon, and thank you everyone for being here. I'm Josh Dankoff, Director of Strategic Initiatives at CfJJ, and I'll run through some slides today to talk about this report, Mandatory Harm, How a Massachusetts Statute Forces Unreasonable Sentences. Briefly, we'll have a quick introduction, talk about what the ACCA is, some critiques, a little bit on the report methodology, and spend most of our times with finding and recommendations. And I'm very pleased to be joined by two esteemed colleagues to talk about some of the impact of this here in Massachusetts. So there are some reports that take a very wide lens, and there are others that take a more narrow one. This is really a focused-in look on one specific law in Massachusetts and the impact that that law has. But even though the numbers of people charged under this law are not very large, the implications are much broader. So first of all, what is the ACCA, the Armed Career Criminal Act? In 1998, Massachusetts adopted a series of criminal justice reforms that imposed mandatory minimum sentences. And this aligned with the 1994 federal crime bill, which was called the Armed Career Criminal Act, or ACCA. Massachusetts law does not actually say ACCA, but that is a term that is used by practitioners in reference to this section, which is MGL 269-10G. And as Leon mentioned in the intro, this is a section that for gun possession, which would normally in Massachusetts carry an 18-month mandatory minimum, it increases that to 3 years or 10 years or up to 15 years of mandatory minimum sentences where the judge has no discretion to lower that if there are previous either juvenile adjudications or convictions of either drug offenses or crimes of violence. This is not the only mandatory minimum law in Massachusetts, and there are a couple other I'll just mention. First of all, that 18-month mandatory minimum in MGL 26910A, and the habitual criminal statute, which requires a maximum sentencing. But what we're focusing on today is what's in the red box there. This is MGL 26910G A, B, and C. I just want to start with some broad critiques of the ACCA, and this is all articulated in more detail in the report, which is now live. And the first is that the ACCA compounds racial disparities. We know from policing practices in Massachusetts and nationally that people of color, Black and Latina individuals, are interacting with the police a lot more due to policing practices that are focused in certain neighborhoods, in neighborhoods of color. And it's those earlier interactions with police that can lead to arrests and these earlier convictions, so that by the time someone may even be qualified for having an ACCA charge added on, these racial disparities get worse and worse, right? The population of who qualifies for this are mostly people of color, and we'll see certainly in the charging practices when we get to the findings that plays out in reality. We're concerned that, and I say may be, but white defendants may be charged at a lower rate than Black and Latina individuals. We have concerns about this. The data, I don't have hard data on this question, but I will say this is a critique that I've heard from anecdotal evidence that this is a charge that the prosecutors can choose, but do not always choose to bring against individuals. And we are concerned that there may be racial disparities in the charging practices as well. A main concern that we have, especially at CfJJ, and for us, this was the hook that got us interested in looking at this statute, is that juvenile adjudications can be used as one of these predicate offenses, or the earlier convictions, or we don't call it that in juvenile court, but can be used as to trigger these mandatory minimums under the ACCA. And we're deeply concerned that, for example, a 15-year-old who maybe got in a fight in school and has an assault and battery case from that case can 10 years later or many years later come back to haunt them as a predicate offense under the ACCA. We're concerned that the ACCA is really used as a prosecutorial cudgel to try to induce plea bargaining, as a tool for plea bargaining, to try to induce longer pleas than would otherwise be available or reasonable. And finally, that the ACCA's definition of violence is overly broad. To look at what was happening in the use of this case, we were using publicly facing trial court data, and we're pleased that over the last few years, the Massachusetts trial court has a data set that is available for anyone to look at. And we were looking at the years 2019 to 2022. We did not look at DA data in the Damien system, and I'll talk about a little bit later some of the challenges with that data and why we did not use that. But we limited from this data set only this charge. But just to note, this data set is only charges. It does not show convictions. We do not know pleas or sentencing. And we don't know, as I mentioned before, who might have been qualified to be charged with an ACCA, but was not. These are areas for further research in this, further research and improved data quality that is public facing that would enable that, or improved cooperation from the trial court and DAs. All right, I'm going to jump into some findings and move forward here. The first finding is that almost half of the ACCA charges in the last 4 years were filed under this 10G Part C, which mandated a mandatory minimum of 15 years. It was just about 40% of the overall charges. And we're concerned about this in that is the most harsh sentence available under this statute. And well, we have concerns about that. The second finding is around race equity. While the population of Black and Latino individuals in the state of Massachusetts is only about 20%, for the charging under the ACCA, Black and Latino defendants are over 75%, which is way out of proportion with the population levels statewide. So we see on this graph, the blue charts are the population levels, sort of population-wide, all of the people in Massachusetts, for Black individuals being 7%, Hispanic Latino 12%, and on the far right, white individuals being 71% of the state of Massachusetts. But in orange, these much higher levels at orange, this difference between the orange and the blue in the first couple of columns show that this statute is really primarily used against people of color. And it really has to bring us to this question of what are we doing here, that we have a law with very lengthy prison terms that is primarily used against people of color. Just to note, these racial disparities shift a little bit year to year. Again, these top blue and orange are the African-American and Latina individuals, and they shift. But even as those shift up and down year to year, and we see sort of a concerning increase of Latina individuals charged under the ACCA from 18 and 13% in 2018-19 to 43 and 38% in 21-22. The percentage of white individuals being charged remains low. Almost all of the defendants who face these mandatory minimums under the ACCA have weapons charges against them. While there are 95 people in total, there were more than 300 charges. So most of the people were facing multiple charges. And we saw that on the left-hand side, we see the number of charges per case, that 18 people had one charge, but as we go down, we see a large number of people had 2, 3, 5, and even up to 10 or 15 charges, and the ACCA was just one of them. Finally, a quick age breakdown. This is primarily used against people under age 35. People age 25 to 44 were making up the almost 75% of these cases. But again, we are concerned at CfJJ about the fact that some of the predicate offenses were juvenile offenses. Now, when we look at which police departments are making arrests that lead to ACCA charges being filed, we see it's really compacted into 3 or 4 departments. So remember, it's not the police departments that are choosing to file the ACCA. That's a prosecutorial decision that happens later. But Boston police and the state police are, those two together arrests from those 2 departments lead to almost half of the ACCA charges statewide, with Worcester, Springfield, and Fall River coming after it. And as this graph shows, these racial disparities track as well and are equally concerning, not more concerning, when we break that down by department. So Boston and Worcester had all but one case of the arrests in Boston and Worcester that led to an ACCA charge were Black or Latina. And also at the state police level, 86%. Even at the departments that had only one or a smaller number of charges leading to ACCA, 45% of those were against Black or Latina individuals. If we break this down at the county level, we see also these racial disparities. Pretty much no matter which way you cut this data, the racial disparities are stark. And I'll say, having worked now in questions of criminal justice and juvenile justice reform for some time, it is a sad thing to see that there are some people who accept smaller levels of racial disparities as a reality in the system. I do not accept those, but you see some people who do. But even for me, when I see these racial disparities, these are really, really shocking to me and out of whack, even with what's happening in other parts of the Massachusetts system. Okay, as we mentioned before, some of the people who are charged under 10G in the ACCA receive these enhanced sentences, these mandatory minimums, based on predicate offenses from when they were a child. The Boston Bar Association did some research from DOC data over a 20-year period that showed that 42 people did have their adult sentence enhanced based on predicate juvenile offenses, and the data was not clear for an additional 67 that it's possible that their juvenile sentences, that juvenile adjudications were being used. So this isn't just a hypothetical, this is a reality that we know is happening here in Massachusetts. The final finding is that we were hoping to look at other data as well from DA sources, district attorney data. Right, the prosecutors have more data in their systems that could have been helpful to sort of provide to triangulate the information that we were seeing from the trial court. But there were a couple of problems with the DA data that ultimately led us to not even do an analysis for this. We're having this a finding in this report because we think the data really should be and needs to be better. So for one, from the data set that we looked at earlier this year, there were a large number of duplicate entries, as well as ambiguity and variation in the charges and sanctions between different counties. The DAs they all use the same data system, but they're using it in such different ways that it's really impossible to compare county to county to what's happening to look statewide. And second, there's as we saw here, doing a race equity analysis was impossible in some of the counties. So this graph here just shows the data that is missing in orange by county where race data is missing. So for example, in Bristol County, 3/4 of the data didn't even have, from the DA system, did not include race and ethnicity, making it impossible to even look at that data. All right. At CfJJ, we don't just look at the data and tell you about it. We think about the impact that this has on our system and have some recommendations that flow from these findings. So the first recommendation that we have is these first 3 recommendations are towards the legislature. And the first one is that we ultimately think that the ACCA statute should be eliminated and encourage need-based evaluation for those who have contact with the criminal legal system multiple times. Now, we don't come to this lightly to just say this should be gotten rid of, but we think that the racial disparities in the way that this is being used overall is so unfair that it should just be fully eliminated. In the alternative, if the legislature does not feel like this is the right time to do that, to get rid of this 1990s holdover law, the legislature should think about doing some modifications that would reduce the eligibility to get rid of 10G A and B, so for the 1 and 2 prior findings, and only keep the one for 3 prior convictions, to also remove the condition that a prior drug offense could act as a predicate offense, and also remove weapon possession crimes from the predicate offenses that could lead to ACCA. We ultimately just don't think it is fair that someone, for having perhaps given the context of what's happening in terms of the opioid epidemic and people struggling with drug addiction, that a drug charge could be the predicate offense for later having them have to have 2 or 3 or 5 times as long prison sentence for a later charge. And finally, to be very specific, we recommend that the legislature remove the mandatory minimum based on prior juvenile adjudications. And we have a specific bill that is currently sitting at State House that does this last piece. To be clear, on recommendations 1 and 2, as far as I know, there are not bills pending right now that do that. We have some recommendations towards the district attorney's offices. As we saw earlier, the practice of doing ACCA charges varies widely, and you have some district attorney offices, specifically Suffolk and Essex, that are using this much more than other counties. And our recommendation to the departments, to the DAs, is that they reduce the use of charging defendants with the ACCA. They have this as a discretionary power to not charge under the ACCA. That if there's a new gun possession charge, there's already 10A available as a tool, and that they fully refrain from charging those based on drug offenses, and I would also add based on juvenile adjudications. We are, based on the finding around the data quality, we really think that district attorney offices across the Commonwealth can develop a higher data quality standard and standardize the methodology of entering data and classifying their data across the counties. The data that we looked at was received based on public records requests, but it's ultimately not that helpful if we get data that is not comparable across the state. And our final recommendation is for further research. This is not the end, but we think that the trial court and the DA offices and academic partners or others should really look at the ACCA and other mandatory minimum cases here in Massachusetts and look at this question specifically of racial disparities, right? This question of, are there cases of similarly situated white individuals who qualify for an ACCA but are not being charged? That would really point to, in a data sense, some of the anecdotal concerns that we've heard that there are selective charging on this case. If you have any other questions about this, there's time for question and answer at the end. We encourage you to take a look at the report. It is more detailed than what I just talked about here today. And we welcome you to follow us, take a look on Twitter or Facebook or Instagram. And any other questions, feel free to reach out, cfjj@cfjj.org. Thank you for your time.
Thank you so much, Josh, for that powerful and compelling presentation. Now we're going, and again, just want to uplift that both our website and the report are live, cfjj.org/mandatory-harm. Now we're going to pivot to the next phase of today's presentation and introduce our esteemed and experienced panelists who will discuss and provide their impressions on the Massachusetts Armed Career Criminal Act and this research. First, I'm honored to introduce Attorney Ducci Gonzalez, who is the Deputy Chief Counsel of the Youth Advocacy Division at the Committee for Public Counsel Services. Prior to her current position, she acted as the attorney in charge of the YAD Quincy Brockton office for over 10 years, where she supervised attorneys and social workers while maintaining her own caseload. Attorney Gonzalez started her career as a public defender, as did I, at the YAD Roxbury office, where she represented juveniles in delinquency and youthful offender matters in the West Roxbury, Dorchester, and Boston juvenile courts. She has also worked as a staff attorney at Suffolk University School of Law's Juvenile Justice Center, supervising law students and representing juveniles in the Boston Juvenile Court and assisting in the teaching of the Juvenile Defender Clinical class. She's a recipient of the Massachusetts Bar Association's 2012 Access to Justice Defender Award. And in 2019, she was appointed by then Governor Baker to the Juvenile Justice Advisory Committee. She earned her bachelor's degree from Boston University and her Juris Doctor from Northeastern University School of Law. Attorney Gonzalez, we're happy to have you, and I turn the floor over to you.
Well, Leon, thank you for that very kind introduction. And thank you, Josh, and your team at CfJJ for all of the work on this report, which really highlights some, as you had stated earlier, some disturbing disparities. And I'd really like to thank CfJJ and Josh for the collaboration with CPCS. This sort of started out of the conversation that Josh had with one of our senior trial counsel attorneys, Patrick Sparks, who I think I see somewhere on one of these squares. Hi, Patrick. And the fact that CfJJ was willing to sort of dive into this issue is terrific. And I think, you know, what I'm going to focus on today is the defense perspective and something that Josh touched on earlier, how the ACCA really interferes with our client's ability to exercise their constitutional rights in litigating the case or going to trial, because it gives so much power to the prosecutors and doesn't leave that discretion for judges. So as Leon mentioned, I'm in the juvenile world, but I think I can speak both as to the juvenile experience and the adult experience. So as a defense attorneys, when we're working with clients, we are assessing the case. Should we file certain motions in a case to, for example, a motion to suppress? And I know in one of the examples, Josh, in the report, a situation like that is highlighted where a young man was found in a car with a gun and there was a motion to suppress. And due to the ACCA, there were issues in that case. And for many of our clients, we share with them all the potential possibilities in going forward with the case. And for a lot of our clients, they're just not willing to take that kind of risk where the ACCA is present because they have minimum mandatories looming over their heads. And although our defense attorneys, both staff and those contracted private with CPCS, provide zealous representation, the one thing that we cannot do is guarantee how a judge will rule on an evidentiary motion or how a jury will decide a case if it were to go to trial. I always tell my clients, I can tell you based on the facts, what I know the law to be, where I think things will go, but I can't guarantee you a certain disposition in a case. And when someone is facing a minimum mandatory, as I said before, people are not willing to take those kinds of risks. And as a result, many clients do end up pleading to a lesser charge that gives them less time. And so this really has a chilling effect on our clients' abilities to exercise their rights to litigate their case or ultimately go to trial. And in many instances, as Josh pointed out, where you have an ACCA, the judge doesn't have the discretion, right? So there might be mitigating factors. There might be an opportunity for a client to be in the community and receive services and resources within the community. But our hands are really tied in those kinds of situations because, as we've said, it gives all of sort of the power to the prosecutor in those situations. The other piece that I really wanted to talk about is recommendation number 3 that Josh highlighted, that talks about the juvenile adjudications being used as predicate offenses. As Josh mentioned, there are 2 bills now pending, House Bill 1688 and Senate Bill 959 that CPCS is also in support of. I see our general counsel and the legislative team here who have done an extraordinary amount of work in advocating for legislation around this. But going back to sort of the thought that juvenile adjudications can be used to enhance sentences in adult court, that's really contrary to the mission and purpose of the juvenile court, and really blatantly disregards everything that we know about adolescent development and brain science. So Chapter 119, Section 53, which provides sort of the law on juvenile courts and the purpose of juvenile courts, really says that kids shouldn't be treated as criminals. And even the Supreme Judicial Court here in Massachusetts has recognized that kids are developmentally different than adults, and they've made that clear in the case law. So the purpose of juvenile court is really to promote the healthy development of children while providing developmentally appropriate consequences for their actions, considering their attributes as youth and what the science and research tell us. And I know Michael's going to talk about the research in a little bit, but the research on adolescent brain development really indicates that adolescents are less able than adults to control their impulses through reason, disposed to overvalue short-term benefits as compared to long-term consequences, and are immensely susceptible to negative peer influences. So let's think about it. Subjecting someone to years of additional mandatory punishment based on something they did as a child is really just fundamentally unjust and unfair. So as Josh mentioned, he gave an example, and there's examples within the report, but for example, someone who had an adjudication for a drug offense at the age of 12, that can be used as a predicate offense. And for a 12-year-old, a 13-year-old, 14, 15, 16, 17-year-old, and as the science tells us, even older than that, for them at such a young age to have the likelihood that their offense will be used later is unreasonable. At a young age, these kids, a lot of their offenses are likely the product of immaturity, impulsivity that's caused by an underdeveloped brain. And it's just too compelling to allow it to be the basis for a severe mandatory adult sentence. Josh had touched on in the report indicates the racial disparities. So youth in Massachusetts who have contact with the juvenile legal system are disproportionately Black and brown children, and often children who are poor. And these youth already face discrimination and disadvantage, and these are the ones that, as the report indicates, are subjected to enhanced and severe punishments in an adult court. So indigent youth and kids of color are receiving disproportionate sentences that are fundamentally unfair. And this is what we see in our practice. So as Josh highlighted, the recommendation, if we could get rid of ACCA altogether, great. But I think there's a lot of research and science that really supports the position that a juvenile adjudication should not be used as a predicate offense. I think I'm going to end there, Josh, and turn it over back to Leon. And I'll be around here if people have any questions, but thank you for your time. And again, thank you, Josh and CfJJ, for your work on this.
No, thank you so much, Attorney Gonzalez, for that lens into how cases pursuant to the statute play out in the courtroom. I know that was incredibly valuable for all our attendees to really get a window into the unfairness that really happens under this law. Now we're going to shift to our next expert, Dr. Michael Roque, who is a professor of sociology at Bates College in Lewiston, Maine. Dr. Roque received his PhD from Northeastern University School of Criminology and Criminal Justice and his master's from the University of Maryland. In addition to his academic experience, he is a researcher whose interests include criminological theory, racial disparities in the criminal justice system, and desistance from crime. Dr. Roque, it's a pleasure to have you, and I turn the floor over to you.
Thank you so much, Leon. And my remarks are really going to be based on the research at large. So I think it complements what was just mentioned and discussed really well based on practice. And so what do we know about a law like this bill and how it sort of came to be and whether the research and data support it? And so what I want to do is talk a little bit about the research on gun violence, the research on sentencing, and things that have changed since this bill was enacted. And I think it's important to provide some context. You know, in 1994, the world in terms of crime was much different than it is today. In 1994, the crime rate, the violent crime rate, was at basically an all-time high, and it didn't look like it was going to be going anywhere but up. So prognosticators were making calls that, you know, we need to get ready for a new wave of violent crime, and, you know, terms such as super predator were thrown around. Some of you might be familiar with those terms. That based on predictions, statistical predictions, the crime rate was going to increase, and we needed to be worrying about juveniles who were going to be career criminals. So that's where this language comes from. And so the 1994 crime bill came out, mandatory minimums, 3 strikes and you're outlaws. The Massachusetts bill is consistent with all of that movement that was basically trying to prepare ourselves for this crime wave that was coming. And the idea was that we needed to lock people up, people who were going to be very, very dangerous and costing society enormously. And so if we can figure out who are the people that are responsible for disproportionate amounts of crime, then we can increase public safety. So what happened after the 1994 crime bill in Massachusetts, in the United States at large? Crime plummeted. Violent crime, property crime, white collar crime, not only crime, but other types of social ills like truancy and disease and teenage pregnancy all dropped substantially, starting right around the time when these laws were enacted. And so you might say, well, these laws were responsible for improving public safety. And unfortunately, the data doesn't really bear that out. Crime was dropping, and was dropping not just in the United States, not just where these laws were enacted, but in Canada, in Europe. Something shifted in society that was not anticipated by statisticians. And, you know, trying to dig down into what exactly happened and why crime decreased so much is a conversation for another day, but there's a variety of theories that are very interesting and potentially explanatory. Now, incarceration is part of that story, but only a small portion in terms of what the research tends to suggest. There is specific research on sentence length, right? Do increased sentences deter people from engaging in criminal acts upon release? And it's really mixed. There's just no consistency. Some research finds that longer sentences are preventative in terms of future crimes. Some research shows that there's absolutely no effect. Some research shows that incarceration makes things worse. And what I think this all boils down to is that we try to create sentencing laws that are based on a one-size-fits-all approach. And the reality is human beings just don't fit that type of a mold, right? And when we create laws like mandatory minimums, what we do is we can guarantee that we're going to increase the incarceration rate at an enormous cost to taxpayers, but we can't say whether those laws are going to be beneficial or harmful for people and for society at large. So longer sentences are given to people for a variety of reasons, some of which have been touched on here before. You know, non-legal factors such as race and gender. Other factors such as the severity of the crime. Other factors such as, you know, judicial discretion and prosecutorial discretion. All of these things have to be sort of taken into account when we want to try to figure out what exactly is the causal impact of a sentence, of an incarcerated sentence. So we can't say that mandatory sentences are actually improving, say, public safety. We can say that they are increasing the incarceration rate. And we know that incarceration is costly, It is something that is effective in terms of incapacitating, but not necessarily effective in terms of improving the safety of individuals once they're released. And I just wanted to also support what was mentioned before in terms of the spirit of the juvenile justice system, recognizing that juveniles are less culpable, that they're developing, the differences in terms of language and the protection of people's record when they are juveniles. If we're going to be using that information to increase penalties in adulthood, then it sort of violates the spirit of that, and could also lead to some labeling effects, some negative effects that maybe are not necessarily anticipated by laws such as these. And again, the goal of this type of law, this type of bill, is very clear, right? The research suggests that crime is not equally distributed across populations, and that we have a small group of people who are disproportionately involved in criminal behavior. And so it's logical that we would try to identify who these people are so that we can selectively incapacitate them. The problem is we've been trying to do that for 50 years and we just can't. Prospective identification of career criminals just simply doesn't work. The data does not support it. There's a variety of reasons for that. And that gets me to the last part of the research that I have done and that I'm familiar with, that I think speaks to this issue. Again, the one-size-fits-all approach does not work, and it's not consistent with what we know about science in terms of individual factors that lead people to engage in crime. We have improved our ability to assess risk. There are tools that have been developed across the country specifically for certain states. Where the state that I live in uses the level of service inventory, that is used to determine how people are treated once they are sentenced. But there are also tools that are used for sentencing. And this takes into account a variety of factors that are not necessarily anticipated by one-size-fits-all approaches that do nothing to really improve public safety. The last thing that I want to mention is one of my areas of research is on something that's called desistance from crime. This is a relatively new area of research, and it has not found its way into public policy as much as other types of research. But what it is focused on is trying to understand when people are less at risk for committing crimes. And there's this notion called the age crime curve that shows people's risk for offending peaks around the age 20 or so, and then it decreases after that. And this is actually based on some of the research that was previously mentioned in terms of brain development. When adolescents are developing and their brains are reaching that sort of full maturity, they're more likely to engage in behaviors that are risky and they're not thinking about the consequences. And then their brains mature and they're less likely to engage in those types of behaviors. So this is desistance from crime. People, even hardened criminals who have been engaged in many, many crimes over their lifespan, they tend to sort of slow down, and eventually they stop committing crimes altogether. And so there's a cost benefit effect here of locking people up in their 20s and 30s and 40s, where their risk is decreasing so substantially that they are no longer posing a public safety hazard. And so that cost benefit analysis needs to be taken into effect, I think, as well, needs to be taken into account as well when we're considering how these bills are influencing public safety, but also taxpayer dollars. And I think that I'll wrap up there. And again, I'm happy to answer any questions or piggyback off of other things that people are discussing here. But I just wanted to say thank you very much for the opportunity to say a few words.
No, thank you so much, Doctor, and just phenomenal. Please express gratitude as you are viewing the both of our experts. They really added so much to this wonderful conversation. So now we're going to transition to Q&A. If you have a question, you do have the option to type it in the chat, but I would encourage you to use the raise hand option under the participants tab, and then we'll call on you. If your question is directed to a particular speaker, be it Josh, Dr. Roque, or Attorney Gonzalez, please include that in your question. If it's in general for everyone, go ahead and simply ask. For those of you who are joining by phone, you can mute and unmute yourself by pressing *6, and you can raise your hand by pressing *9. So with that, we welcome any questions. So one came in, is there a link to the presentation? Yes, we will have the presentation up on the mandatory harm webpage at cfjj.org. You're welcome. Any other question from any of our attendees? All right, we have a question that came in from Harsha, and I'll read this for all three of our experts. What efforts have been made or are being planned to address the issues of inconsistent data entry and classification in the District Attorney Management Information Office Network, also known as DAMIAN? And how might improving data quality impact the ability to assess and address racial disparities in ACCA charging and disposition effectively? Given that that's a data question, Josh, I'll start with you, but any of our experts, feel free to chime in.
Sure. Thanks for the question. Well, the DA offices here in Massachusetts, as elsewhere, operate a little bit like islands into themselves. And that means that while they share the system that would enable policies and practice to all the data to be entered in the same way, the reality is that it's wildly different place to place. And even within, we've seen some of the data even within some offices. So I don't know of any efforts. And I'll say I just don't know of any efforts. Certainly the data itself has not improved over the last few years. It was sort of the same challenges that we saw in 2019 were still there. I know the DAs have asked for a large sum of money to update their data system. And I don't have a specific opinion on that, except to say that the challenges that I'm talking about here don't actually have to do with problems with the system. It has to do with how the system is being used and inconsistent use of the system. So even a lot of money to make a new system, if it's again going to be used in an inconsistent way, is not going to make any improvement to our ability to understand what's happening. To the second question, how might improving the data quality enable us to assess? Absolutely. We'd be able to, if there were more pieces, and just to say, the trial court could also release, improve the data that is being released and have a more of an understanding of not just charges, but what are the outcomes of cases, and have a better understanding of the impact of pleas. And there could be, to my question, I know that the data systems it is possible to pull out these questions of, who could qualify for an ACCA charge but wasn't charged, and break that down by race. That would take either going courthouse to courthouse to look at actual charge sheets in person, because most things are happening on paper, or it would take a data use agreement from the trial court. I probably wouldn't trust the DA data system to answer that question. And I don't know if Attorney Gonsalves has anything to add on that.
Thank you, Josh, for your response. Any other questions from our audience? Hearing, oh, Ted Lucas, thank you. Are there any successful models or best practices from other states that Massachusetts could consider when reforming its use of the ACCA? I open that up to our entire panel.
hoping Professor Roque jumps in first.
Sure. Yeah. I mean, there's a lot going on right now in terms of reforming the justice system. In Maine, in particular, we were actually the first state. I'm in Maine. We were actually the first state to abolish parole and to lean towards these more determinate sentencing, where people would be sentenced to long periods of incarceration, and the idea was incapacitation and deterrence. And we've recognized that over time that this was a mistake. This led to mass incarceration. This is, ineffective in terms of understanding why people come to the justice system in the first place. And so there's strong movement toward bringing parole back in Maine, and there's very good evidence that it would be helpful. Maine has one of the lowest incarceration rates in general. For Massachusetts, I think it's really interesting because the mandatory minimums are something that, again, contextually were enacted at a period where crime seemingly was out of control, and it was peaking, and crime decreased after that. And so just eliminating mandatory minimums there's no evidence that it increases crime. Secondly, in terms of Massachusetts itself, I don't know if this is common knowledge, but Massachusetts has the lowest gun death rate in the country. And for the last 10 years or so, the gun death rate has increased in Massachusetts, but that's solely due to suicides. The gun homicide rate has actually decreased. So Massachusetts is really in a place where reform should be palatable to the public. And I think that reform in terms of just removing mandatory minimums has been shown not to be negative in terms of increasing crime, but also Massachusetts is in a good position to eliminate it and determine whether that actually has the beneficial or negative effects.
Thanks. I'll just add, there are efforts around the country in different states to reduce mandatory minimums. Certainly Virginia and New York, there are bills probably sitting in most of the state houses around that. The challenge is that some lawmakers fear a political blowback for being seen as soft on crime. I think we've pushed beyond that a little bit in Massachusetts, and there's certainly room to do more. I'll just drop in the link, well, at least one case from Virginia, though this is not necessarily a best practice.
Thank you, Josh. One other question from Michelle Xavier. Is there survey data on public opinion about the ACCA? Josh, given that you led this research, I'll ping that to you.
No, I don't think it's this is, as I said at the beginning, this is a pretty narrow topic. So I don't think this is something that is even most people would know about enough to do a survey on the general public. I think if you talk to people who are practitioners in the field, there are a lot of concerns, certainly on the defense side, on how it is used in practice. Thanks for the question.
We have a couple more minutes, so one last call for any questions. Hearing none, again, just want to take a moment to thank all of you again for attending. Big thanks to our experts, Dr. Roque and Attorney Gonzalez, for lending us their expertise. Again, you can download a copy of the report, www.cfjj.org/mandatory-harm. We'll also be uplifting pieces of the report on our social media at CfJJMA on Twitter and Instagram, Citizens for Juvenile Justice on both LinkedIn and Facebook. And we hope that you will give us a follow and keep track of not only this research report, but I will go ahead and put him on the spot and say Josh is also planning several other research reports that will be coming in the following months. So this is the first of several that we will have. But again, we thank you, we appreciate your support, and we thank you so much for joining us today. Have a good afternoon, everyone.